I'm not going to spend a lot of time speaking about Cliff. He's a nationally recognized authority on the legal problems of small business, and he also was the host of Money Hunt. And it goes on and on. You can go online and see get more information about his background. It's rather interesting. I've known Cliff for a number of years, and last time we were together was on a panel about 4 years ago. Now, the topic is intellectual property and other sticky issues in consulting contracts. And it's not a very sexy topic, but Cliff is the type of person that can give this type of topic legs, and he will do that. I can assure you that. But before we start, let me just give you a little bit of the things that you should know. This is a very interactive presentation. Cliff will speak. If you have any questions, you can ask or use the chat form. This is a complicated issue, and sometimes it doesn't lend itself to using chat. If you think you can use chat, please do. But please interrupt and ask the question. Cliff will go on, and I think as we discussed it before, discussed it. There's my Spanish coming into play. I don't want to say he's disgusted. As we go on, he will frame his presentation in a way that will give you the opportunity to ask questions and perhaps offer your own observations. So, Cliff, take it away. And
hey,
again,
thank you, Juan.
as I said before, you have his email, and if you have any questions you want to follow up, please contact him. Cliff, take it away.
Great, Juan. Thank you very much. Well, Juan gave me a very, very good introduction. I'm not going to bore you with anything more. He's already told you the bad part, which is I'm an attorney. So I'm a little surprised that half of you haven't logged off. That's what usually happens with this. But let me just sort of tell you two things about myself, just by way of just establishing whatever bona fides I have in this area. Number one is the fact that I do somewhere between 50 and 75 consulting contracts a year for my clients. I represent a motherload of consultants around the country, and it's all on the consultant side. I wish I had a Fortune 1000 corporation as a client, but I don't think that's going to happen. I just don't. This is not the look that Fortune 1000 looks for. I have to work on that a little bit. But the other thing is I have a YouTube channel with about 25 videos that are pretty much entirely for people that are doing your kind of work. If you go to youtube.com and search for my name, which is Cliff Enico, just like it spells right there, without the exclamation points, you will have a listing of all my videos. And the one that the two that you're probably most interested in is one called Copyright Basics, which is really good for artists and photographers, but it's also for consultants as well, and Trademark Basics. If these are, most of you sound like you're beyond the basic level of things. You kind of know the difference between a copyright and a trademark, but if I'm mistaken about that, these are two videos that are getting a lot of traction on YouTube. I'm becoming a viral sensation in terms of, in fact, I actually have a video on YouTube with over 100,000 views, which I'm very happy about right now, although it's not appropriate for today's topic. It's on how to sell anything to anybody. A lawyer teaching you how to sell better. Now, is that whisper or what? Anyway, so with that as sort of an introduction, let's get into the topic today. This is a world that is rapidly changing. I think it's fair to say that even as recently as 10, 15 years ago, my consulting clients were not really hung up on intellectual property issues. They were more concerned about getting paid on time. That was, the big issue, and it's still a big issue in consulting contracts, by the way. I see a lot of consulting contracts that, while they're crystal clear on a lot of other things, they're very loosey-goosey about exactly when the client gets paid. It's amazing. It almost seems the bigger the client and the better the legal representation that they have, the more loosey-goosey this language is. So, but that's a topic for another day. But today, that is no longer the case. Just about every consultant that I work with has intellectual property that they want to protect, number one. And also, this is a world that is where the psychology is changing. It used to be that people didn't think, oh, I got this workbook at a seminar, I can make copies of this and put this on my website. That wasn't the mentality 10, 15, 20 years ago. But today, we live in the world of the internet, where information is free. Information wants to be free, dude. You know, I see stuff on the web. I can use that. You know, it's public domain, man. This is the attitude. And forgive me, the California people on the call, my apologies for imitating your everyday speech. But this is the world that we're living in now, is a world where there's a greater expectation that information can be used, and that it is not copyright protected. Those of you in the software world, I heard a couple of software people here in the audience, you know, when I mentioned the word open source, your hair stands on end, because you live with this. One of your greatest challenges as a software developer and publisher is making sure that you don't accidentally make your product open source by signing the wrong contract when you bundle your software with other things. You get this, but it's increasingly happening in the world of the printed word as well. Next time you're online, Google the phrase copyleft movement. Copyleft as one word movement. This is a movement within academia to change our copyright laws, so that instead of the default being everything is deemed to be protected unless you assign it or license it, the default is going to be anything that is published is presumed to be open source and available for republication and reprint unless the author deems it otherwise. They want to take our copyright laws that have been around since the 1700s and turn them and stand them on their head. So this is a major, an area that is in great flux. And not just in the copyright world, but in the whole world of intellectual property as well. A lot of people are wondering if it's a little bit too easy to get a patent on certain types of inventions. People weren't asking these questions 10, 20 years ago, but they are today. So let's begin with the beginning. If you're a consultant, you have two concerns about your intellectual property. And since this is football season, I'll refer to them as a defensive strategy and an offensive strategy. The defensive strategy is very simple. You want to make sure that people who have access to your material, to your proprietary content, do not have the right to reproduce it at will, willy-nilly, in a way that causes your business to suffer. That is what I call the defensive strategy. And that is the defensive strategy. The offensive strategy is when you see people using your stuff, having ways in which you can shut them down legally and effectively. So those are, I'm just going to call those the defensive strategy and the offensive strategy. When we're talking about contracts, we're talking mostly about the defensive strategy, focusing, getting language in the contract so it's very clear what the client can and cannot do with your copyrighted or other protected materials. But you've also got to have an offensive strategy too, where, I will confess to you, I am an author. I have 15 books in print. I've got thousands of articles on the web. Sometimes I don't even know they're on the web, but all of a sudden I see them there. And I am very concerned that people, usually, by the way, it's other lawyers. I have to tell you this. The worst offenders here in my world are other lawyers who see one of my articles and they take it and they just change the name and a few other things and they try to publish this as their own. It's amazing to me that lawyers who should know better about this stuff are the worst offenders in this case. So again, you need a defensive strategy and an offensive strategy. So let's just, what I want to do, I really want to make this interactive. I want to spend the bulk of the hour answering specific questions that you have and focusing on specific language you can use to make things just a little bit better. But let me just talk 5 or 10 minutes about the one clause that always gives you a heart attack, which is the assignment of rights. Sometimes it's called the assignment of inventions clause because it comes from the patent world. Sometimes it's called assignment of work product. Okay, there's most consulting clients that you will see, and especially for Fortune 1000 clients, will have a clause in there that is like that. That is because these companies are in the business of hiring consultants to produce custom content for their business, for their customers, for whatever. If you are being asked to do something specifically for a client, to create content specifically for a client for which they are paying, the company may have some rights to ownership of that work product. if you are doing it specifically for them. So if I get a call from IBM saying, Cliff, we want you to put together a very specific workshop for our senior management on the legal aspects of social media marketing. How can we, if we see one of our younger employees putting garbage up on his Facebook page that he shouldn't be doing, can we fire him? What can we do? And we want you to do this program specifically for us, and we want you to create this content specifically for us. That is a situation in which I may be required to sell that program to them. And there is a possibility that after I'm done with this program, they can use that material over and over and over again. There's not a whole lot I can do about that if that is what is happening. But for most of you, that's not what is happening. What is happening is you have a program that you have created on your own time with your own equipment. The program that I just described, by the way, is one that I do for various corporations around the country, especially companies in the tech space that have a lot of younger employees who live on social media and their smartphones. They don't realize that they shouldn't be talking about projects at work when they're on their Facebook page, that kind of thing. But it's a program that I developed. I didn't do it for that particular client. I may customize a slide or two for those people, but it's my product, and I don't want them owning a piece of it. I certainly don't want them using it in a way that's going to be detrimental to me. So that's the situation that you find yourself in. How do you protect yourself against that when you are faced with this kind of a clause? Well, first of all, most of you already, I think, know the difference between a license and an assignment of copyright. When you assign your copyright to someone, you are selling it. You are telling, there's no difference legally between an assignment and a sale. You are basically signing your rights to this company, saying, you have the right to use this program any way you wish. Now, that is not what you want to do if this is your protected copyright. What I always tell my clients to do, and this is where I come in, is have a clause developed by an attorney, that is for you specifically, and that is specific to the material that you have developed. Okay, so here's where I'm going with this. The best protection in this situation is when the client submits you their onerous assignment of work product clause. It's always a good idea to say, you know what, I see that clause in there. I see clause 7. Just so you know, I don't normally sign those. I have, this is proprietary content. I think when you wrote this contract, or your attorneys wrote this contract, you had this in mind for more like customized work. And this is not customized. I am doing this seminar for a lot of clients. Here is my standard clause that I like to see in this agreement. How much of this could you please run this by your attorneys or your internal people and see how much of this you can live with, and write it in such a way that it's balanced and it's fair to both sides. I can, somebody like me can help you with that, drafting that language. Always have a form clause that you can send them so that you're being proactive. You're not just marking up their contract and marking up their clause, but you're being proactive, saying, here's what I am willing to do. Because here's the nasty reality here. When you're in a situation like this, where you're doing a program for a big company, and especially if they're recording it or they're videotaping it, whatever, you really have no way of preventing them from using that material internally after the program is over. That is the reality here. Right now, I am doing a program. It's tied to my new book on equity crowdfunding. Using crowdfunding sites to raise money for your company. The SEC finally allowed that. The new regs are going to be effective in May. I'm going to be doing programs for bar associations around the country. And the very first thing that I did was, because I knew this was coming, every bar association has a form of presenter's contract. The first thing that I did was I sat down and I wrote a paragraph describing the fact, here's what you can do with my program, and here's what you cannot do with my program. You can certainly record the program. You can video. You can do one video replay after that. But anything beyond that, I want a royalty. Which can either be a percentage or it can be a flat fee. For this one, it's probably going to be a flat fee. But there are 1 or 2 bar associations who have indicated that they want to do this for 3 or 4 consecutive months right after the regs come out. And that's fine. If they want to pay me a little bit extra for that, I'll let them do that. But the one thing I cannot control is if somebody who is an attendee at this program takes my slides and my presentation, my PowerPoint, and decides that he wants to become the next crowdfunding expert, there's not a whole lot I can do about that. The only thing I can do then is develop my offensive strategy, which is how do I shut these people down? When I find them, how do I take them down? And what are the proper ways of doing that? So I just want to say that, by the way, but develop a clause of your own that is blessed by a lawyer that specifically says that what they're getting is the non-exclusive license for their employees only for the particular session. Make it as limited as you possibly can, and include language saying that it cannot be reproduced, yada, yada, yada. Okay, now, let's say the client agrees to that. Life is beautiful, okay? But let's just say the client doesn't. Let's say, no, we really cannot, just take your clause. I see where you're going with this. Take our clause and just, make a few changes to it, and we'll run it by our counsel, and if they're okay with it, we'll run with this. Okay, number one, you do not want to sign, if you are the author of this copyrighted material, you do not want to give them an assignment. You want to give them a non-exclusive license to use the content for specific purposes only. That's number one. Number two, one thing I always put in my clause, and this happens so often, every week just about, I make this change. It always make sure that the license only takes effect when you get paid. The biggest mistake that companies make when they do the assignment, they say, upon signing this contract, you hereby license all of your content to us, yada, yada, yada. What that should say is, upon receipt of payment in full for the services herein described, consultant hereby licenses. Do you see what you've done there? You've made a contingent upon payment. I think I see that every assignment of work product clause that I have ever seen has that clause in it. Second thing you need to do, invariably the work product definition is defined as something that was customized for that particular client. So the next thing you want to do in the clause is you want to specifically exclude work product that is developed for other clients or that you use for your clients generally. I would almost put that language in quotes. In every work product section, assignment of work product clause, there's a clause, section that defines what the work product is. And it's usually very general. Any artwork, documents, memoranda that you develop for the company at the company's request, fine, but then you've got to put, or your attorney should put at the end, provided, however, that work product for purposes of this agreement does not include any stuff that you have developed either independently that you use for your clients generally, or work product that was specifically created for another client. That second part is very important also, because if you are using a program that you have developed specifically for another client and you made it more generalized, whatever, there is a risk that without that language in there, you could end up with conflicting claims to the ownership of that content. That's a secondary issue. I don't really want to get into that on this program. So,
Cliff, a quick one?
Yes, sure, go ahead.
This also then addresses methodology as a way of protecting methodology, because you may have developed a methodology, you apply all the knowledge you gain about that client to be able to deal with their issues.
That's exactly right. The second thing that has to be in the exclusion of work product, okay, anything that you do for other clients, anything that you've developed independently and that you use for your clients generally, that's magic language. The second thing you want to see is language that specifically includes any ideas, concepts, know-how that are not reduced in writing generally. I always try to get that. You're using the word methodology, which is a good one, but I like a more legally precise definition. We're in the same place. I just want the wording to be a little bit different. The idea, in the course of doing presentations, I learn stuff. In the course of this presentation, you guys are going to teach me a couple of things, and I want to be able to throw that into my presentation that I'm doing for the New York State Bar Association tomorrow. I don't want to have to pay you a royalty or get your permission. So that's the secondary part of this. We will talk a little bit later on about, when can you use stuff, on your website. So anyway,
can I ask a quick question, Cliff?
Sure, absolutely.
What's the difference between what you're talking about right now with work for hire versus work for hire?
Okay, let me make it. It is work for hire.
Okay.
Okay, a little legal introduction. If I am your employee, if I am your W-2 employee, and you ask me to write an article for a blog for your website, and I write that article and that blog, even though I am the author, I have no copyright to it because the work made for hire doctrine says anything I write for you in the course of my employment belongs to you. I don't have to assign it to you because I'm an employee. The employment relationship is what creates the work made for hire. However, because of a 1989 Supreme Court decision, in fact, a little footnote, it was the last opinion that Justice Thurgood Marshall wrote for the court before he retired. He retired right after this opinion. But he wrote this wonderful opinion saying, if someone is an independent contractor, however, and you hire me as an independent contractor to write something, some original content for you, even though you paid me for it, I still own the copyright and all of the intellectual property. Unless I assign that copyright to you, okay, that content belongs to me even though you paid for it. That is why we have the assignment of work products clause, because of that Supreme Court case. Until that Supreme Court case, I very rarely saw these kind of clauses in contracts. But after that case, attorneys started scaring their big company clients saying, because of this, Thurgood Marshall, he changed the law on this. We got to have, and every contract, whenever you ask anybody to do anything creative, you got to get an assignment of the copyright, or else you don't owe it. That contractor can use it for with all your competitors, everybody else. Our profession is responsible for all this fear within the industry, and that is why you get these assignment of work product clauses in contracts now. And again, and if you are doing something legitimate that you are creating for them for a very specific need, and they are paying you for it, you might have to assign your intellectual property to that specific thing. Now, being a lawyer, of course, I have to slice things very thin. I'm like the world's best butcher. I use the 0.1 setting in doing the thickness on the salami slices here. Whenever a client asks you to customize one of your presentations, so very frequently, I will get a call from somebody who says, hey, Cliff, I saw your YouTube video on this, whatever. I really want you to do a customized version for our membership. We represent electrical contractors. We want you to speak at our annual convention. Can you do a version of that specifically for the electrical contractor market? Okay, that gets a little hairy because I'm taking something that I own, but then I am customizing it, and you are paying me in part for that customization. So who owns the finished presentation at the end of the day? Those of you who are in the software business, this is just like a bundled product where you have a base software product, you integrate another company's software product into yours, and you hold it out as a separate version of whatever your product is. It's exactly the same issue that you get with there. I frankly refer sometimes to software contracts when I'm doing this kind of negotiation from my clients, because software people have had to deal with these kinds of issues for years with bundled products. It's like a value-added reseller thing that I'm doing for folks. But I don't want to get into that. That's really advanced stuff. The assignment of rights clause can be tricky. The thing is to be very clear about, at the end of the day, what do you own? And at the end of the day, what are their rights to these things? Okay. Now, it may very well be, depending on the type of consulting that you do, if you're charging for seminars, okay, I always say in my standard assignment of rights clause, okay, I cannot prevent people from republishing this content, but I can prevent the client from doing other seminars on the same, using this content with their in-house people. And there's very specific language in my contract that says you can use it for the purpose of this seminar. However, any additional use of this content in seminars or programs for your employees, customers, or others requires a separate contract and additional royalties payable. If they want to take my content and use that for other internal programs, I can prohibit that. What I can't prohibit is, one of the attendees making copies of this and sending it to everybody in his division saying, boy, this guy Cliff Enico is a genius, he's great, look what a great job he did, this is what we're going to be doing from now on, this is what you tell your people. I really can't prevent that. I don't even know what's going on. The best way to address that, quite frankly, if you're dealing with a client that's likely to do that, is with pricing, quite frankly. You should price accordingly. And when somebody during the pre-call said that they work with top 40 contractors, Fortune 40 companies, and they generally don't have this issue, I have to tell you that has been my experience as well. If you're dealing with a Fortune 50 or Fortune 100 corporation, they generally do not play these games. Your bigger risk is going to be with the early stage entrepreneurial company that frankly is operating in a more loosey-goosey manner, and they've got people who, what can I say? They're online stealing stuff left and right anyway. This is just one more thing for them to steal. You really got the bigger risk in a company where the culture may be more open than the button-down world of the Fortune 100. So just to let you know, I do agree with that concept. The bigger the client, the more reputable the client, the less you have a practical issue with this kind of stuff. So anyway,
Cliff,
go ahead.
Question about assignment of rights.
Yep.
I recently was asked to write an article for a major publication in Canada, and the article was reflective of the system that I just developed and shared with you earlier. I didn't sign anything, and they didn't pay me anything for the article, but I wanted to be able to use the article again myself on my web page or in marketing materials. So I asked them what my the copyright assignment would be, how I would be able to use it again. And they basically said I could use it, but I had to say that it was published in their magazine.
Okay, that's fair. I don't think I would have a problem with that. The one thing, though, and let's talking, this is a good introduction to the offensive strategy. Okay. Up to now, I've been talking about the defensive strategy. When someone wants you to assign their stuff to them and you don't want to do it, how do you prevent that? How do you control, your copyright? Now I want to talk about the offensive strategy here. First thing is, whenever you author anything, whether it's for compensation or not, you always put your copyright notice at the bottom of each page. The C in a circle, Clifford R. Enico, 2016, all rights reserved. That's the standard copyright. That has to appear everywhere on your web pages, electronic copies, PDFs. Do it as a footer on every page. That tells the world this is copyrighted material, cannot be used without my permission. That's basically what it is. And you may want to give permission. I get calls all the time from academics around the country, college professors, who want to use articles of mine in their customized case books and stuff that they do for their students. I never mind that. As long as I put my name on it with a link to my website, I'm not going to charge them money for that. I want, the lawyers of tomorrow to know that Cliff Enico existed. I'm not expecting to get any royalties on that. There's no such thing as perfect copyright protection. But I do want to make sure that they ask me for that permission. The second thing that you can do is on your website, okay, you should have something called a permissions and release policy. Okay, when you have a lot of content up on your website, it's a very good idea to have a document. A lot of people put it and they bury it in their terms and conditions or their web terms of service. I like to see it, though, as a separate document, because when I'm looking at a website wondering, gee, can I use this or not, I really want to see permissions and release. I want to see those words, because that tells me, okay, that's the document that's going to tell me what I can use and what I can't. And there are standard forms of this. In some cases, you don't mind them using stuff, so anybody can use any articles on my website as long as they put my name in, an attribution to my website. Be a little specific. Be very careful here. There is technically no copyright on legal forms. You can take somebody else's terms and conditions and, cut and paste them and make them your own, believe it or not. The only thing I ask you, please, as a lawyer and as a friend, if you are using somebody else's document, let's say it's one of mine from one of my websites, be sure to take the other person's name off it. Okay, I hate it when I look at a client's website and the terms and conditions begin by saying, welcome to Apple or welcome to IBM. Believe it or not, people do that. They forget to do a spell check. They forget to do a search for the term. Go through the bloody thing and make sure that the other company's name is taken off that. But have a permissions. That'll save you a lot of headaches. Otherwise, you're going to be spending at least an hour a day answering emails from people who want permission to use your stuff.
I have another question, Cliff.
Go ahead.
Because you said you could add your copyright on basically anything you write.
Right.
At what point do you actually submit to the Copyright Office? Then why would
I'm going to answer that if you could. I'm going to hold up because I want to get one more point across about the offensive strategy here.
Okay. Thanks.
This is what everybody on this call I think wants to hear. I have a little dirty trick that I do. In all of my content that I have published on my website, I include very little unusual terms of phrase. I will say something in a very unique and distinctive way, no more than 5 words. But in every one of my articles, I have 2 or 3 of these, I call them man traps. Okay, and I'm not being sexist in any way about that. It can be a woman trap too. I call these man traps. These are little phrases that are unique to me. And what I do then is, after I write the article and after I post the PDF up on my website, I take out Google alerts for each one of those phrases. See, most people, when they're trying to steal your stuff, they know that that if they change the title of the article, well, that title's not going to show up in a Google Alerts search. But I go a step further than that. Yes, I do a Google Alerts for the title of the article, but I also bury some of these little man trap things in there. 3 or 4 little turns of phrase that I know are unique to me and that only I use. The odds of somebody else coming up with those independently are going to be very, very remote. And then I do Google Alerts. And you'd be surprised how many other attorneys I catch, where they changed the title of the article, but they kept in some of my man traps, and those are being picked up by Google Alerts. So then I can write them a very nice, friendly cease and desist letter from a fellow member of the bar. One of the nice things about being a lawyer, I hate to say it, I can scare the crap out of people. When I send a cease and desist notice out, it tends to get attention. People do take down the thing, whatever. Okay. So now I apologize, but I just wanted to get that one point out, Allison. The question you raised, which by the way, I also handle on my Copyright Basics video on YouTube, is a lot of the times you don't want to publish in the Library of Congress. You don't want to go through the process of filing the Form TX and filing with the Copyright Office. And there's a very good reason for that. Unfortunately, there are a lot of people out there, we call them copyright trolls, Trolls, whose sole purpose in life is to comb through the copyright records and look for stuff that they can steal. Not necessarily, and a lot of these people are not just, evil people sitting in basements, members of ISIS or anything like that. A lot of these people, believe it or not, are hired by publishers and other creative companies looking for the next great idea. So let's say you do a piece of fan fiction, some Star Trek thing or something, and you register it with the Copyright Office, okay? I don't want to steal your book, but what a great idea. I think I want to write my own book on that theme, on that topic, okay? I'm not going to steal your words because that's going to get me sued for copyright infringement, but I will steal your idea, which is not protected. You cannot protect an idea with copyright or anything else. So what I tell my clients, in your case especially, I would do what used to be called poor man's copyright, what we used to call it poor person's copyright. Print out, you say it's an Excel spreadsheet, print it out or put it on a CD or a DVD in some tangible format. Make 2 or 3 copies in a tangible format. Stick them in an envelope and mail them to yourself. Mail them to yourself. Okay, seal the envelope. Make sure it's sealed in such a way that it isn't easy to open. And mail these things to yourself. What you're looking for here is the postmark date. When the envelopes come back to you, and hopefully they'll be postmarked with a date, do not open those envelopes. Keep them in a drawer, in a closet, in a safe deposit box somewhere. Because if anyone ever tries to rip this thing off, the first thing they're going to say is, well, we came up with this ourselves. Okay? And when did you come up with this? Oh, well, last month. Well, I have a sealed envelope here with the CD saying, that on April of 2015, I created this. what the reason why you want to copyright something with the Copyright Office is you want to establish proof of origination. You want to show proof of authorship, that on a certain date, you were the one that wrote this. This article was in existence under your name on that certain date, okay? By publishing it with the library, with the Copyright Office, you are opening it to the entire world. By doing the poor person's copyright, you stand a chance of getting to the same place, but without having to disclose your content online. Sorry, a long-winded answer to a very simple question. Okay.
Thank you.
Okay, let's start talking. I've been kind of doing all the talking here. Let me hear from some of you. One, I don't know how, don't all start talking at once.
There's a question from
does
JB.
anybody have a question?
Yes, there's a question from JB that came through chat. JB, are you still unmuted?
Oh, I didn't see the chats. Here it is. What about situations when subcontracting to an organization, private or public, through a prime, where the prime has no input on content, when nature of work is essentially custom, and the prime is simply finding a firm to provide something they cannot provide? Can someone elaborate on that? Because I'm not sure that
I think I understand it. This is a situation where you, the consultant, are acting as a subcontractor for a prime contractor, and the ultimate client wants customized content. Okay? Okay, the key here is customized. If you are indeed creating customized content for that particular client, for that aspect, and you are getting paid for that, you may have to surrender some rights to the stuff that you have created specifically for that content. What I would do, though, in the subcontract is I would also remember when I say in every contract the term work product is defined, and usually defined pretty specifically. I would put language in there specifically saying that the work product excludes tools, content, and other material that I have either developed myself and that I use with my customers directly, or stuff that I have done for other clients. Remember, that language gets you out of a lot of trouble there. So even though you structured this as an assignment of the specific content, to the extent that that content incorporates your standard templates, your standard forms, the standard slides that you do for everyone, that stuff will not be assigned, but will be the subject of a non-exclusive license. Now, the thing you should do here, I know this gets a little wordy, and I apologize for that, but right after you do that, you make that change, I would put in a clause saying, and as to those other things that I have created, the client will have a non-exclusive right in perpetuity to use those materials. So the client at the end of the day wants to know that they own, or at least have the legal right to, anything that they have paid for. And that's the way that you get around that. You distinguish between the stuff that you're doing specifically for that client, which they do own, and the stuff that you use generally in your practice, which is the subject of a non-exclusive license. I will say non-exclusive rights in perpetuity. I don't want to start a fight with the client. A perpetual license means that they can use the materials, forever as much as they want to, as long as they don't make any changes to it. They don't have the right to do that. Another great tool, by the way, I always, especially if it's a PowerPoint, I always put some kind of a disclaimer in there saying these materials are valid only as of the date of the presentation. I am not responsible for any changes due to changes in the law and stuff like that. See, I'm lucky in a way because all my stuff is dated, and it gets dated very quickly. Then I do a presentation, it's out of date 3 months later. So it's easy for me to say, if you want to use an out-of-date presentation, be my guest. But I'm warning you that even a month from now, some of the stuff I'm talking about today may no longer be valid. That's another way of the offensive strategy of letting the world know, look, this information, if you're thinking about stealing it, don't even bother, because it's probably going to be out of date a month from now. Or a year. Certainly the stuff I'm doing on crowdfunding right now falls into that category. We're going to learn a lot about crowdfunding in the next year. And I can't assure you that the stuff I'm saying today is still going to be accurate a year from now.
Cliff.
Yes, Juan.
And this is a question that some people might be interested in. Sometimes a client will ask you for a confidentiality or a disclosure agreement. Is there any reason why we shouldn't always sign those?
Okay. Generally speaking, confidentiality clauses, I don't get excited about them. If a client is disclosing trade secrets and things to me, well, geez Louise, I should be empowered to keep these things confidential. The one thing you have to be careful about, look at the definition of confidential information and make sure that it doesn't inadvertently pick up the stuff that you do for your clients or customers generally. Because the thing you have to watch out for, the confidentiality clause is a no-brainer. It basically says, I shall not disclose any of your confidential information to the world at large. But there's a second part of it, which is called the non-use clause that says, and I will not use any of that information for my own purposes in my practice for my other clients. That's the part you got to watch out for. When I look at a confidentiality clause, there are some very standard exclusions to the definition of confidential information, and I want to make sure that they're broad enough to protect the stuff that I independently develop without using the client's resources, equipment, or time that I use for my clients generally. That's a very important exception to me. That's the one little thing. Other than that, confidentiality, non-disclosure agreements, I think they're pretty harmless for the most part.
Here's another question that came in. How can you protect a business model you developed? Lynn Bogart.
Hi, Lynn. Okay, a business model that you have developed? Okay, this is tricky. Okay, I mean, I'm sorry, I can't hear her, so I'm assuming she's muted or whatever.
I'm here.
Oh, hi. Could you be a little more specific without giving away details, obviously, of what you do?
Yes, I have developed a business model which involves training professionals around the country for a specific purpose to serve a particular market segment. Some of that training model will include my intellectual property, and that's kind of a separate question. But this question is, this whole structure was my idea originally. How can I protect that?
Wow. Okay, I got it. Okay, well, first of all, the business model itself is probably not protectable. Mm-hmm. There used to be a time in the very early 2000s where there was something called a business process patent that you could get. So, for example, one of the famous online shopping websites was able to get a business process patent on one-click shopping. There was where you click one button and everything happens. The patent office has really turned against those in a very big way because they're too broad and they're too defined. What they're saying more now is that a business process or a business model like yours is an idea which is not protectable. Unfortunately, you may be able to treat it as a trade secret. If it's something that you use yourself but you don't disclose as part of your presentations, if it's a way that you have found to do things differently, you might be able to keep it as a trade secret, which means you don't file it. You don't file it anywhere. You just keep it to yourself. But if you are teaching people how to work the model, the actual words, the actual text, when you say the intellectual property, the copyrighted or trademark material, the copyright or trademark is protectable, but the idea, the model itself, is not protectable. So what you might want to consider doing is give it a very funky name, something that is perhaps trademarkable, and then build your program around the trademark. So if other people want to teach the same way of doing business, they can do it, but they can't call it what you call it because that is unique to your brand. You see what I'm saying?
Yes, and that leads me to a kind of sub-question, which is, if it's a standardized set of processes to provide a service, could we service market?
The answer is you might be able to service market, but it's going to be tough as heck to enforce.
Got it.
You're going to, what do you send to the Library of Congress? You're not going to send just the concept. You're going to send a specific set of what? Of like a flow chart or something like that. See, that's the thing. You can copyright a specific concept, but you cannot copyright an idea. So you could copyright a flow chart, for example. Anybody trying to teach this model cannot use the exact same flow chart that you have. And that's what that copyright, again, your copyright notice should always be at the bottom of everything so that at least, if God forbid someone does rip you off down the road, you can at least get into court and try to fight or send them have the basis for doing a cease and desist.
Right, I've always done that at the bottom of every page.
Yeah, it's a knee jerk. You just do it every time. Because without that, you don't really have any protection at all. But
so what can you service mark then if you have these processes by which you're providing service?
A service mark is just how can I say it? Well, it's a trademark. A service mark is a trademark term. It's not a copyright term.
Understood.
That is all. So the little SM simply means that you can you can do whatever you want to do, but you can't call it what I call it. Cliff the LLC guy, might well be a service mark. If I'm forming LLCs in a very standardized web method, like a garage or something like that, and I want to call myself Cliff this LLC guy, I could probably shut somebody else down who's trying to use Cliff the LLC guy, but I certainly cannot stop the tens of thousands of lawyers around the country who are forming LLCs. I can't tell them to stop doing their business.
Understood. Thank you very much.
I hope that's clear. I know it's a little vague. It's a little bit like, here's my metaphor, which if you look at my copyright basics thing, the copyright for something is not the thing itself. Picture a work of art. Picture a famous painting. The Mona Lisa, let's say. We all know what the Mona Lisa looks like. You can all picture it in your mind, okay? And let's say that you've got the original Mona Lisa sitting on a table. Now, pretend for a moment that hovering above the Mona Lisa is a hologram, a 3D hologram that looks exactly like the Mona Lisa, but it's separate and apart from the actual physical painting that's lying on the table, okay? That is the copyright. Think of it as a 3D hologram, okay? So when you sell the painting to somebody else, a museum, maybe if it's just the Mona Lisa, that's probably who's going to buy it, or some gazillionaire, Donald Trump or somebody like that, who can afford to buy it, okay? You can sell the painting, but unless you also sell the rights, the hologram, you get to keep the hologram yourself. If you are the author, if you're Leonardo da Vinci who did that painting, you get to keep that hologram. The rights are separate and do not flow with the right themselves, the painting itself. So if you're an artist and you sell a painting to somebody else, they can keep the painting, they can sell it to somebody else, they can destroy it, they can do it. They can't change, but they cannot change it because you kept the copyright to that painting. They cannot make reproductions of it without your consent. They cannot do lithographs or serigraphs or anything like. It's a lot easier to do this with a work of art than a literary work. But you get the picture here?
I do. Thank you.
The rights flow differently than the physical object itself. So, but that's that. I'll defer you to my YouTube. I really want to get beyond the basics here and focus specifically on consulting contracts and the issues that come up with these things.
Good. Thank you.
Yeah, with regard to that, as you speak about consulting contracts, Cliff, sometimes clients may not include something that you really should have. Not that they do it intentionally. Is there anything that must be in there or should be in there?
Yeah. Oh, the answer is absolutely yes. This is just a general question on consulting contracts. People always ask me, Cliff, when I do a consulting contract for somebody, especially when I've reviewed somebody else's contract, they always ask me, Cliff, should there be something in there that's not in there? That isn't in there? And the answer is yes. There should be a bunch of things. First of all, there should be language in there that says specifically when you get paid. I'm going to return to this topic. You'd be amazed how many contracts I see that are crystal clear about the services that you're going to perform, the statement of work and all of that. And they're very clear on what your hourly rate's going to be or your per diem or whatever, but they're not clear at all about when payment is due. Mm. That is kept loosey-goosey. When I look at my theory of contracts is, and especially most of my clients are a lot smaller than the people they're working for. You're not going to get everything you ask for when you're dealing with a Fortune 1000 corporation, okay? But at the very least, as long as the contract is clear on what services you're doing, what you're not doing, how much you get paid, and most importantly, when payment is due, I can live with a lot of ambiguity in the other stuff, in the other contract language, the indemnity clause, the subordination and attornment clause, whatever. I can live with a lot of nonsense there, as long as I know my client's always going to get paid at a very precise time. Because that's when the rubber's going to meet the road. That's when I'm going to get the frantic call from the client when the client hasn't been paid on time and he feels that the money is due to him. That's when I'm going to get the client. That's when I'm going to get the frantic call in the middle of the night. I know that. The other thing that you should put in is a clause, to the extent that you can. With a big operation, this is probably not feasible, but I have very standard language that I put in that says that the client will respond to requests for information, additional follow-up, that they will respond to drafts within a certain. Those of you who are marketing consultants, you know what I am talking about. You do the web design, you send it to the client, and then you never hear from them for a month or two. There has to be a point in there where you say, okay, if you do not respond within a certain time frame, then I have the right to terminate this agreement. I get to keep what you've paid me. Maybe I charge a breakage fee on top of that, and any new work that I do will be the subject of a separate contract. Especially marketing people get into that kind of problem a lot. Always have a clause that allows you to get out if the other side refuses to cooperate. You're not going to get that from Fortune 100 corporations. Smaller clients and individual clients, you probably will get that. And if you don't ask, you don't get.
Good point. Here's another question. Came in from JB. Can you speak a bit to using referencing copyright materials in one's own products or output?
Okay. Yes, let's talk about that. That's a major topic. The key words here are fair use doctrine. Those are the magic words here. Google, next time you're online, Google fair use doctrine. And this is primarily in copyright law. Generally speaking, the copyright law says that if I own a copyright to something and you want to use it, you either have to get my permission or pay me a royalty. You cannot use my stuff without either getting my permission, or if I find that you're using it without permission, you got to pay me something for using it. That's the basic copyright law, which I say the copyleft people want to change all that, but that is the law today. Fair use is an exception. It's a series of rules that say under certain circumstances you can use my stuff, as you know, and you can get away with it. You don't have to owe me anything. This is the clause, this is the law that got us all through college. When all of us wrote our term papers and we copied slavishly from articles that we did, right? We all did it. Okay, let's be very fun. We're going back to the 60s and 70s. Remember Kate Turabian, the lady who wrote the footnote books about how to do the footnotes, right? This got us out of a lot of legal trouble, because what the fair use doctrine basically says is that under certain circumstances, if you use my material and you give me attribution to it, under certain circumstances, I can't do a thing about it. I got to let you do it. Now, the myth here is there is no set number of words or pictures or musical notes that you have to do. There's this myth out there that as long as I use less than 50 words of Cliff's article and I give him credit, I'm okay. That is not true. There is no quantity limit like that. Okay? The idea is if you're stealing stuff from me and I really, really don't like it, I can probably shut you down. But here's reality. There's copyright law and there's reality. Okay? And I'll give you a very good example of this. About 10 years ago, a young law student somewhere out in the Midwest did a web page on the 100 best books for American law students. It was just a book review site of what he felt the 100 best books you got to get if you are in law school anywhere in the United States. And I'm very pleased to say that 2 of my books, I actually have a series of books for young lawyers that I've written, career guides for young lawyers. That's one of the things I do. Other things I do when I'm not doing stuff like this. 2 of my books were in his top 10, and 5 of my books were in his top 100. I was very, very proud of that. Okay. Now, what he did was for each of these books, he did a synopsis. He talked about the book, what it did, and then he also. This kid must have had, I don't think this kid was really a law student. He had too much time on his hands, but he actually typed one of the chapters of each of these 100 books. There was a sample chapter of each of these 100 books, which he must have, I don't think, this is in the days before scanners. He must have just sat down with a bottle of bourbon or something and just typed these paragraphs over and over again. Now, that is copyright infringement, no question about it. He's taking a whole chapter of my book. He's using it without my permission, but let me ask you this. Am I gonna shut him down?
No.
Am I gonna fight him? He's doing me a great favor. He's saying that 2 of my books are essential reading for law. I mean, I want to help this kid. I want to give him more stuff to use. A lot depends on what the use is. But when you see people using your stuff, first of all, if they're giving you attribution and if they're giving you a link to your website, they are not stealing it. Okay, they're not really technically infringing your copyright. The big question is, are you losing money because of this? Now, if that kid's website had been the 100 worst law books for American law students, and he put 2 of mine in his top 10, I would have reacted to that a lot differently than I did with the 100 best books. Again, it all depends on the purpose. There's copyright and there's reality. There's no such thing as 100% copyright protection. There is no way that you can prevent, there is no way that is 100% effective from keeping people from stealing your stuff. My advice to you is, if you're planning to use somebody else's stuff, first of all, look at their website, see if they have a permission and release policy. Because they very well might. If it's an author, if it's somebody like me, there's probably a permission and release policy on the website that says, you can use some of my articles if you do A, B, and C. Then just make sure you do A, B, and C when you reprint it. If there is no permission and release policy on the website, I would email the guy and ask him for permission. You got to be. A lot of times I get these requests. I'm flattered that people want to use my stuff. Some professor in Montana wants to use an article I wrote 5 years ago that I forgot I even wrote it. Hey, great, more power to him. Just put my name on it, a link to my YouTube channel. Dude, I'm cool. You'd be surprised if you ask how many times you'll be allowed to use the thing. Again, of course, there's always the risk that the person will say, yeah, and I want $10,000 for it. Yeah, but to be honest with you, if they do that, then you know you have a problem. And I'll give you one last piece of advice. If we're talking photographs, okay, if you're thinking about using a photo that appears on the web, make sure you check the Getty Images database on Getty Images and make sure that they don't own it. Getty Images owns the right to millions and millions of photographs that you think are public domain, but they are not. Getty Images is the world's largest photo bureau, and they own the rights to a lot of things. The photograph at the end of World War II of the sailor kissing the nurse in Times Square, the one we all know, this photo, they own the rights to that photo. That is not a public domain photo. You cannot take that photo and use it on your website. Check the Getty Images database, because I will tell you something. If Getty Images owns the rights to that photo, and they find out that this has been on your website, they don't even contact you. They send you a bill for $35 for each day that photo was used on your website without permission. They can tell when you uploaded that photograph onto your website, and for each day after that, they will charge you a license fee of $35, and there is nothing you can do about it. I have argued with Getty Images. I have spoken to their lawyers. I have tried to fight. Sometimes I'm able to get that reduced, but I have never been able to make it go away. Even if you take the photo down the next day, they want their royalty, and they will hire lawyers and they will come after you. So if you're thinking about using a photo on your website, check the Getty Images database. And if you see it there, the good news is their license fees are very reasonable. Most photos in the Getty Images database, you can license for maybe $10, $20. And it's a perpetual license. You can use it on your website forever. It's when they catch you stealing that the baseball bats come out and life becomes very, very nasty. Be careful. Some people are very ruthless about enforcing their copyrights. If you steal any of my stuff and you're using it in a way that I think is going to hurt me, the nice guy Cliff Enico disappears, and you see why I went to law school as opposed to becoming a missionary or some other publicly positive purpose.
Cliff, we're getting close to 4 o'clock. I have 2 more questions.
Go ahead, Kim.
I'd like to ask you a wrap-up question. I know you have another commitment. So here are 2 questions. Any definitive thoughts on professional liability insurance, EOs for consultants, and particularly for possible IP infractions of clients? And then the other question is on how do you check Getty Images to see if it's there?
Oh, well, the second one is simply just check I apologize. I think it's gettyimages.com. I don't have the URL tattooed on my brain, but just go to the website and then describe the photo, or, if you see it somewhere, you can actually you can put a link saying, I want the right to use this photo, whatever. Do you own it? They have ways of searching this material, but by all means, check it out. Don't assume that the photo, especially if the photo has a photo credit to a photographer, that photo credit has to appear on every use of. I don't want to get into photographs. That's a very specific topic. I actually give these talks for photographers, believe it or not. But let's go back to the first question, which is insurance, because that's the other thorny thing that you'll find. Eventually, sooner or later, a client will ask you to provide insurance, in certain amounts. Okay, first of all, every consultant should carry some basic level of insurance. Commercial liability is not so important, but what is really important is your errors and omissions, especially if you're in the computer field, the IT field, marketing. This is insurance that is designed to protect the client against your mistakes. You use a photo as part of a client work product that you didn't own or that you didn't have the right to use. That's what that stuff is all about. Everybody should carry at least $1 million of basic coverage. This is malpractice insurance for non-lawyers and non-doctors. That's what E&O stands for, errors and omissions. Everybody should have some basic errors and omissions coverage. Very often, a client will ask you for more coverage than you have. What I always tell my clients to do is just send them an email and tell them what you have. And 9 times out of 10, as long as they know you're carrying some insurance, and if they want you badly enough, they will go along with whatever you have. You will not have to purchase additional insurance to meet your requirement under that contract. Be careful, but I always make sure to have that conversation with them. Don't sign an agreement saying that you're going to carry $2 million of E&O if you only have $1 million of E&O, because then you've breached your contract. You've misrepresented yourself to the client. Don't do that. Tell them what you got. 9 times out of 10, they will go along with that. But there are certain things you should never sign. So, for example, if you are the only person involved in your consulting business and they require you to get workers' comp insurance does not apply to independent contractors. It only applies to employees. If you are the only person in your company, if you're a one-person LLC or a sole proprietor, you are not required by law to carry workers' compensation in any state of the union. So if there's a clause in the contract that says you got to carry workers' comp insurance for $1 million, what I tell the client to do is I scratch out the $1 million and I say, you'll carry workers' comp insurance to the extent required by applicable law. That's managed language. So if the law does require you to carry workers' comp, wink, wink, I don't know any state who does, you'll take whatever the statutory minimum is, but not otherwise. You got to read the insurance clause very carefully because, again, these big companies especially are used to dealing with other big companies. They are not used to dealing with you working out of your spare bedroom in your bunny slippers, who doesn't have $5 million of errors and omissions insurance. There's going to have to be a very candid discussion about reality here. One last thing about insurance clauses. While it's perfectly okay to say that the client can be named as an additional insured on the policy, if the clause ever says that they will also be the loss payee or the named loss payee under the policy, you need to fight that. That means that if there is a claim under that policy because of work that you did, they get the money before you do. And that is not a good thing. If any client wants to be the named loss payee on one of your insurance policies, frankly, I consider that a deal point. You need to walk from that contract. If they want to be an additional insured, that's okay. That just means that their interests are covered as well as yours. That's not a big deal. Any insurance company, you might have to pay an extra $10 in premiums every year, but it's not a big deal to add a client as a named insured. It is a big deal to name them as a loss payee. Don't do that.
Let's wrap up. What are some provisions, 2-3 provisions that everybody should have in a consulting contract?
Okay. Well, again, to protect themselves, I always like to get a clause in there. It looks like boilerplate, but it really isn't, that says that both parties waive what are called consequential damages. That's consequential damages are like ripple effect damages. You drop a stone in the water, we all know the story, a butterfly flaps its wings in the condo and we get Hurricane Katrina. Things sometimes have results that spill out of control. What a waiver of consequential damages clause does, and it should be in every one of your contracts, it says that neither party is liable for consequences of their actions that are not reasonably predictable. So if you are an IT consultant and you're working on a nuclear power plant and you get a little something wrong, you allow a virus to get into that power plant, and we have Chernobyl, part 2, you are not responsible for anything beyond the direct damages of your causing the virus. You are not responsible for causing World War III. Okay, that is what a waiver of consequential damages clause should be. In every one of your contracts, it should absolutely save your life. Another clause I like to get into my contracts is a clause that specifically requires the client to cooperate within certain time frames, especially if your fee quote is based on an hourly basis. I have to watch out for this because I quote a lot of flat fees, and inevitably when I quote a flat fee, something happens which is going to require additional work on my part. Always make sure whenever you quote a flat fee to put language in your contract that says it is based on an assumption that I will not do more than X hours on this. If it turns out that I will need to put more than X hours in, I will contract you and we'll do a change order before we change anything. The other thing you have to watch out for is many consultants will put something called if you have insurance, they will put a waiver of subrogation clause in there. That is a clause that says basically that if you do foul up for some reason and the insurance company pays out, that the insurance company may be able then to come after you for the shortfall, for whatever it is. Be very careful about that. Some insurance companies do not like waiver of subrogation clauses. So if a client wants a waiver of subrogation clause, before you blithely sign it and assume that it's boilerplate, talk to your insurance company first and make sure they don't have a policy against waiver of subrogation clauses in insurance, in your consulting contract. So those are some things that I think you should look out for that go beyond the intellectual property side.
Cliff, absolutely the last question, since it was asked. So are photos from morguefile.com okay to use? Are they really from Getty and okay to use?
I don't really know about morguefile.com, but there are a bunch of sites that are from photo bureaus that are recognized. It's always a good idea to check these, and if you're not sure, I would just simply email the person, email the site that you're looking to take it from, especially if it's an original photo that that they put up there. When in doubt, no one will ever fault you for asking for. Now, having said that, what typically happens here is they don't usually sue you. It costs money to hire lawyers and bring lawsuits. I will share with you that in just about any part of the country, it's going to cost between $10,000 and $20,000 for someone to bring a lawsuit to sue anybody in court. Rational people, are not going to spend that kind of money just to knock somebody off who inadvertently used one of your articles or something like that. Rational people are not going to do that. What they are going to do is they're going to send you a letter saying, cease and desist. You're using my stuff without permission. If you don't do anything, I will have no alternative but to commence all legal action against you. That's what will happen. So if you're not really sure and you want to use the photo or use the content, whatever, chances are they're not going to sue you. They're just going to send you a nasty cease and desist letter. But Getty Images will not. Getty Images will come after you. So that's why I'm especially concerned about them. If you violate the rights of some other photo bureau, they'll probably send you some kind of an email notice, but Getty Images is just ruthless. And I have to say, I've spoken to some of their lawyers. Their attitude is, look, we stand, when we work with our photographers, we stand in a fiduciary relationship with them. They are trusting us to make sure that they get every penny of royalty that they are entitled to for their creative work. If we do not enforce this aggressively, we are not honoring our fiduciary relationship to our photographers who we see as our customers. Look at it from the other side. As a content creator, and especially if there are any photographers in the audience today, wouldn't you rather work with Getty Images than anybody else in the photo world, given what I just told you? You want to work with them, don't you? Absolutely. So enough said.
Cliff, I want to thank you on behalf of everyone for a information packed full hour and 10 minutes. It was fantastic. I know, I believe others will feel the same way that I do. This was absolutely outstanding.
Well, thank you. I know I can't answer all the questions, but send me an email. You have my email address in the program thing, and if I have time, I will try to answer it. If you're asking me a really thorny, detailed question, I will call you. I will not just start charging you. We have to establish a lawyer-client relationship. But if any of you have contracts that you want me to look at, you should be aware that I do have a minimum fee of 1 hour of my time for reviewing a contract, consulting contract. That's $300 currently. But the good news here is that 95% of the time, your fee will be the 1 hour minimum fee for my contract. I will tell you in advance if it's going to take me more than 1 hour of my time to look at your contract. So if you have a contract you want me to review, send it to me. If it's going to take me more than an hour, I will let you know. Otherwise, your bill will be $300. I'm prepared to offer that to all IMC members.
2 more things before we sign off. Remember, this is being recorded so that if you want a copy, you can obtain it from Judy, and you'll be able to review this. And I certainly am going to do it because there was information there that was just absolutely outstanding. So that's number 1. Number 2, the next program for next month, how many people here would like to make money? How many people here want to be paid what they're worth? So if you're interested, the next session we have is called, Are You Being Paid What Your Services Are Really Worth? So anyway, thank you everyone for participating, and virtually everyone stayed on to the last second. The very best to you, and thank you for participating in C2M Live. And Cliff, a million thanks again.
Always a pleasure. Whenever you need me, call me.
Thank you.